You know, when a homeowner decides to take their HOA to court, you kind of know what to expect, right? It's usually a fight over rules, or money, or landscaping. And this story, it's got all of that. But what happens when the whole fight ends not with a big victory or defeat, but with a legal twist so strange it changes the entire game? Let's dive into this bizarre case of mistaken identity.
So this is how it all ended. Just like that. Case closed, petition denied. But why? The weird thing is, the judge never actually made a ruling on whether the HOA was misusing funds or hiding records. So to figure out how we got to this really surprising outcome, we've got to go all the way back to the beginning.
All right, so what was this whole fight even about in the first place? It all kicked off with a petition filed by a homeowner named Donald Molley back in August of 2022. He had two really big issues with his association, the Verde Meadows Crest HOA.
Now, the complaints themselves seem pretty straightforward, right? On one hand, Mr. Molley was arguing that the HOA was using community money, everyone's money, to take care of private property, specifically the front yards of all the townhomes. And then on the other hand, he claimed that when he asked to see the financial records and the meeting minutes to prove it, they just shut him down.
And during the hearing, he brought receipts. Well, not literal receipts, but he got really specific. He testified that the HOA was spending $750 a month on landscaping. He pointed to this one incident in April 2022 where they removed 4 or 5 pine trees from different properties, and he estimated it cost over $1,000 for each tree. His whole argument was pretty simple, really. The association's own rulebook, the CC&Rs, says pretty clearly that owners have to maintain their own lots.
But, as you can imagine, the HOA had a very different story to tell. And their defense wasn't just about trying to explain away the spending. No, they went much bigger. They challenged the entire foundation of the case itself.
And boom, here it is. This is the quote that flips the whole story on its head. The board president, Kari Wickenheiser, actually said this during the hearing. It sounds like a strange thing to say, right? I mean, what does that even mean? But this one statement is the absolute key to understanding how this whole thing ends.
So the HOA's defense wasn't just this one-liner. They really came out swinging. First, they argued that they're just a nonprofit, not what the law considers a planned community. They also claimed their own bylaws specifically allow them to use dues for landscaping. And then, and you gotta love this twist, they claimed the reason they couldn't hand over the 2022 financials was because Mr. Molley himself, who used to be the treasurer, never turned them over when he left the job.
Now, before this all blew up in the final hearing, the case had to jump through a few hoops just to get in front of the judge.
So yeah, you can see there was a little bit of back and forth here. The hearing gets scheduled, then canceled at the last minute, then put back on the calendar. Finally, everyone meets for the big showdown on January 5th, 2023. Okay, this is it. This is where the case takes a hard left turn into completely unexpected territory. The judge's final decision had nothing to do with landscaping or trees or who had the financial records. It all boiled down to one single, fundamental question of legal identity. You see, the agency that was hearing this case, the Arizona Department of Real Estate, has a very specific job. It only has jurisdiction, which is just a legal way of saying the power to make a decision, over two very specific kinds of HOAs. Condominiums and planned communities. If an HOA isn't one of those two things, the department literally can't do anything. It's like taking a parking ticket to a divorce court. You're just in the wrong building. So first up, the judge had to figure out, is this a condominium? Now, the key legal phrase here is undivided interests in the common elements. All that really means is that everybody shares ownership of common stuff, like the hallways, the pool, the roof, the land underneath it all.
So, the judge looked at the evidence, and what he found was that at Verde Meadows Crest, the town homeowners don't share ownership of any common areas. Everyone owns their own lot, plain and simple. So, checkmark next to not a condominium. All right, so if it's not a condo, could it be a planned community? Well, for that to be true, the law says the association itself, the nonprofit corporation, has to actually own and operate some real estate. It has to hold the deed to some property, like a community park, or private roads, or a clubhouse. And this was the nail in the coffin. The judge looked into it and found that the Verde Meadows Crest Homeowners Association, the corporation, doesn't own any property, not a single square inch. No common areas, no land, nothing. So it didn't meet the legal definition of a planned community either. And there you have it. The knockout blow, straight from the judge's decision. Because the association wasn't legally a condo association and it wasn't legally a planned community, the Department of Real Estate had zero authority to hear the case. The whole thing was just thrown out. Not because one side was right or wrong, but because they were in the wrong court altogether.
So a local TIF in Arizona gets dismissed on a technicality. You might be thinking, why should I care? Well, because the lesson learned here is way bigger than just one neighborhood. This affects everyone.
I mean, just think about this for a second. We never got an answer. We still don't have a legal ruling on whether the HOA was misusing money or if they were wrongly hiding their books. The judge had to dismiss the case, so those huge questions are just left hanging. The homeowner did exactly what you're supposed to do. He took his problem to the authorities, only to find out they were completely powerless to help him.
Honestly, this case is a massive wake-up call for anyone who lives in a community with any kind of association. The fine print, the legal definitions, they are everything. That definition decides what laws apply and, maybe most importantly, where you can even go to fight your case. Just because a group calls itself an HOA on a sign doesn't mean it fits the legal definition that gives you, the homeowner, certain rights and protections.
And that really leaves us with one last and maybe the most crucial question of all. It's not just about reading your bylaws, it goes deeper than that. It's about knowing the legal ground you're standing on. So do you really know the official legal classification of your HOA? Because as this case proves, finding out you're in some kind of legal no man's land when you're already in the middle of a fight, well, that might be way too late.